Our system of justice faces serious problems. Problems that are increasingly apparent from media reports on police and legal corruption and false confessions. We learn about these problems from high-profile cases. But there are countless other cases of injustice that remain unreported, either because they are deliberately hidden or lack public interest. This is my son, Erich. His story could remain an unexposed example of injustice, in this case due to lawyer and police corruption in Milwaukee, Wisconsin. I want you to know my son's story. The major sources of failure in our legal system are misplaced empathy, favoritism, and the power to violate the rules.
Sometimes people break rules if they want to win.
In Milwaukee, my son's life was balanced against the careers of influential figures in the legal system. They feared exposure and criticism for their negligence. Erich and I, justice and the law, all lost out to favoritism among police, lawyers, and a judge. They worked within the same system, knew each other well, and protected each other. Denying justice to a citizen to protect insiders is easier than acting against the interests of people you work with every day and who influence your career. When a case is not watched closely, even well-established facts can be hidden to protect individuals in the system. My son was severely abused in Shorewood, a suburb of Milwaukee. My efforts to protect him from harm lasted for years and included child services, law firms, the police, social workers, physicians, hospitals, and courts. Concealing these documented efforts became crucial later to protect insiders. Unwilling to continue to watch as my son deteriorated and ignored repeatedly by the legal system, I finally took him away from an ill and angry mother and Buddy, the abusing boyfriend. I took Erich away to safety, where he thrived. I knew when I left with Erich that I might be caught, but I would draw attention to his abuse and it would have to stop. I was caught, but I was wrong about what could remain hidden, even in an American courtroom. The legal system in Milwaukee took immediate steps, but not to help Erich. The system in Milwaukee protected the careers of the very people who had ignored my calls for help for years and who now felt vulnerable to criticism. They hid facts, protecting the abuser and themselves. I wanted to expose negligence and wrongdoing, to defend myself against the charge of interference with child custody at an open trial. I had protected my son in compliance with Wisconsin law. But the judge and my own lawyer insisted on a plea bargain. They wanted to protect careers. I refused plea bargaining through 17 months of intense coercion by my lawyer and the judge. They used my son as bait. There had been political pressure. Judge Hancher didn't want a trial that highlighted an abusive mother in his courtroom or that exposed negligence by colleagues. Hancher and my lawyer wanted me to agree that Erich had not been abused and that I had taken him away without cause. In return, I would be able to see him again and avoid jail time. I angered both Kohler and especially Hancher by refusing the plea bargain. They retaliated at the trial. I was denied defense witnesses, none were permitted. Supporters and witnesses were intimidated from the courtroom, some in tears. Jury selection was deliberately skewed to exclude jurors who felt that child abuse was a serious offense. All documented evidence, including hospital, police, and court records, was hidden from the jury, as my defense lawyer worked against me in favor of the police, for whom he had worked many cases. Hancher, Kohler, and the prosecutor focused on protecting the police, other lawyers, and the Shorewood social worker, Connie Pexton. Of the accusations that I make, the concealment of public records, including court records, with such ease from a jury should cause the greatest discomfort and concern to Americans. Anyone can verify these claims by comparing court records prior to trial with the prosecutor's statements at trial. The records you see here constitute proof that I complained vigorously, often, and to many agencies and authorities about the abuse in advance of taking Erich. These documents would have made it impossible to convict me under Wisconsin law, but their exposure would have meant difficulties for the people who did not act to protect Erich. That is why these documents and many others were concealed from the jury. In an American courtroom, a cooperative effort by Judge Hancher, prosecutor Fred Matestik, and my own lawyer, Martin Kohler, concealed official records and intentionally misled the jury. Unrestrained by the judge or my lawyer, Prosecutor Matestik simply lied to the jury. As the ultimate display of cynicism, Matestik even asked the jury, "Why is there no history of complaints?" As he spoke, he knew that extensive records were being concealed and that my lawyer would not object. What about the legal appeal? After agreeing to expose the wrongdoing, lawyer Stephen Glynn backed down. He feared Hancher and Kohler in particular. Glynn appealed my guilty verdict based on a legal technicality. He refused to expose his colleagues. 12 years later, Chief Banazinski finally released other evidence that was hidden at trial, evidence that would have changed the course of my son's life. Only after I applied unorthodox but legally permissible pressure on him from Switzerland did he admit to having that evidence. Judge Hancher had also been involved in the concealment. But then a further interplay of favoritism in the system occurred. The Milwaukee District Attorney, John Chisholm, continued to conceal the evidence released by Banazinski. This injustice was intended to remain forever disguised in a distorted history. What about media coverage? It was absent by design. Kohler and Hancher dissuaded them. Future cooperation from Hancher and Kohler, prosecutors and police, on higher profile cases was more important than justice for one individual. As early as 1999, I had begun to disclose corruption in the Milwaukee legal system through mailings and publications. The individuals I named were not happy. The process of demonizing me began back then, and it escalated the more I published and the more I resisted. Not long ago, Fox News 6 helped further conceal the wrongdoing, drawing attention to me as a stereotypical fugitive. With the focus on me, it isn't on corruption in Milwaukee. How I had called on every avenue of legal redress for years, and how each effort protected local figures at the expense of justice, was never mentioned. In the United States, despite the myth, the freedom to publish the truth can be fleeting. Lawyers exerted financial pressure on me for my refusal to stop publishing. They even intimidated the printers of my booklets. U.S. Marshals in Milwaukee spread false information. I had no criminal record until I protected my son and angered the Milwaukee legal establishment. Their description of me as armed and dangerous is groundless. The intent is to overshadow this story with fear of me. I have undertaken no action that deserves an Interpol note. This is an attempt to silence me, an open critic of a failed American system of law enforcement and justice. The one thing that does remain credible about the American justice system is that a public relations machine goes to work far better than the legal system itself. Sued and prevented from telling this story at home and facing rewarding the very lawyer, Martin Kohler, who colluded with the prosecutor, I finally left for Switzerland, the country of my birth and a nation renowned for defense of freedom of speech? Swiss authorities are and have been aware of my unusual circumstances for many years. Unlike Milwaukee, in Switzerland I am free to publish and to expose Milwaukee corruption. At a young age, Erich had to choose between freedom from pain or love of his father. I saw the effects of pain inflicted by his mother. I understand the choice he had to make. I'm Erich's father. Erich's abuse included being put in garbage bags and the use of water to cause fear, a method that showed no telltale signs. When I decided to take Erich away, he had been assaulted by extreme violence and close-range rage. He was temporarily paralyzed and emotionally devastated. When he saw me again, his small hands clung to my neck in a way that I will never forget. It was my moral duty, but also my legal duty in Wisconsin, to stop the abuse. Lawyer David Jarvis saw my son in that condition in his office at the Quarles and Brady law firm, but refused to inform Judge Francis Wasilewski. Protecting colleagues was the priority. That pattern repeated over and over, and Jarvis wasn't the only one. Erich experienced violence to stamp out his love of me. I regret to say that, to date, the effort has succeeded. I have not heard from Erich in 16 years. My goal is to reunite with him. A disturbing and counterintuitive fact about child abuse is that violence can create a bond between an abuser and a victim. That bond can masquerade as parental love for a long time. I tell this story to release Erich from an emotional prison. There is no shame for him. There should be shame for the people I expose. They hid abuse, protected an ill mother, and violated the law, and until I left Milwaukee, they controlled this story. The wrongdoings that I disclose are not fine points of law. They represent a major failure of justice, and they separate me from Erich to this day. My trial was staged to show the public that police and lawyers always do their jobs, that mothers never harm their children, and that something bad never happened in Shorewood. The men named here want history in their favor. They make my life difficult by promoting false internet information, hoping that power and fear will hide this story. While unattainable in the courtroom, I seek a measure of justice now through public awareness. I ask for your support by pressuring the people I name, letting them know that you have seen this film. I know that the description of my trial is remarkable, even astounding. The tricks and traps set by lawyers and aided by judges to achieve the plea bargain are eye-opening and mind-boggling. No one should remain unaware of how the system uses deceit in individual cases to serve narrow interests in violation of law. Wisconsin law protecting children is excellent. It simply wasn't enforced. My desire to see Erich and to protect him was used as bait in a cat and mouse game to obtain the plea bargain. Few Americans realize the extent to which reaching a plea bargain has become the sole purpose of our legal system. For further information, on my site I describe in great detail how justice was undermined in my case. The methods used are surely not limited to my case alone. Thank you for watching, and thank you for showing your concern.